Hello friends, welcome to Ambitions Made Easy channel. Today we are going to discuss a very important topic which is called anti-defection law. First, we know the complete concept, then we will discuss how UPSC asked preliminary questions based on this topic. Let us start. Let's start with the definition. Before going to clear the definition, we should know what is the historical background, what is the reason behind its origination. As we know that the India is a republic country, means citizens of the country elect their representatives. Elected representative belongs to different political parties in which majority winning party leads the government. Now the stability and potentiality of that party depends on the loyalty of the representatives. If the member or representative disobey the party rules, or if members jumps from one party to another party, subsequently defected, leading to political turmoil in the country. Let us understand the above paragraph by recalling the famous political phrase Ayaram Gayaram. In 1967, Gaya Lal, a Haryana MLA, changed his party thrice within a single day. The same day, it leads defection in the political party system. About 18 years later, sought to prevent such defection, the then Rajiv Gandhi government had brought anti-defection law through 52nd Constitutional Amendment Act in 1985. It introduced a new schedule to the Constitution, that is 10th schedule. Let us know what is the motives behind the anti-defection law. They are: first, to curb horse trading of legislatures who belongs to parliament or any state assemblies. Then, to curb political corruptions. Then, to strengthen the democracy. Then, aim is to bring political stability and demand accountability from the legislatures and obey the political party directions. These are the main motives behind the framing anti-defection law. Very most important part of this topic is what are the provisions, on what basis disqualifications are made, on what ground and which situations disqualifications applicable to. First one, if any member of a house voluntarily gives up his membership of such political party, then he is liable to disqualifications. Second, if any member votes or abstain from voting in such house contrary to direction issued by whip or his party without obtaining prior permission. It means if any member who is intended to abstain from voting as a direction given by the party, then he is liable to disqualifications. Third one, if any independently elected member joins any other political party after election. Carefully see that. Third one, if any independently elected member joins any other political party after the election. Fourth one, if a nominated member joins any political party after the expiry of 6 months from the date on which he takes his seat in the house. Don't get confusion between third one and fourth one. Third one clearly mentioned that is belongs to an independent member. He should not join any political party. Fourth one, if a nominated member joins any political party after the expiry of 6 months. These are the two main points you should carefully remember it. Then, when disqualifications not applicable, what are the exceptions are made from disqualification? The conditions are: first one, if a member took a prior permission of his party for abstain from voting within 15 days. It means any a member who intended to abstain from voting, he should get prior permission of the party within 15 days. Second one, if a nominated person joins any political party within 6 months, he is not liable to disqualification, as already we know that disqualifications are made when nominated person joins any political party after expiry of 6 months. You should careful on that. Third one, when two-thirds of the members of the particular party have agreed to merge with another party. This is the very important provision which was inserted by the 91st Constitutional Amendment Act 2003. The most important points to know that: first, presiding officer of the concerned house decides the disqualification on the ground of defection. Second, in Quixote Holohan case, the Supreme Court declared that decision of the presiding officer is not final and can be questioned in any court. It means it is subjected to judicial review on the grounds of malafide and perversity. The most important point is to remember that: is there any time limit within which the presiding officer has to take decision regarding defection? The answer is no, because anti-defection law doesn't specify a time limit for the presiding officer to decide on a disqualification plea, given that courts can interrupt only after the presiding officer has decided on the matter. The petitioner has no option but to wait for the decision is to be made. It means there is no time limit for presiding officer to decide the disqualification questions. Now discuss how UPSC asked in prelims on this topic. The first question is: which one of the following schedules of the Constitution of India contains provisions regarding anti-defection? This question is asked in UPSC Civil Service Prelims examination twice, in 1998 and 2014. They are asking which schedule of the Constitution contains the provision regarding the anti-defection law. Already we discussed it is the 10th schedule, because 52nd Constitutional Amendment Act inserted a new schedule, that is the 10th schedule. Second question is: which of the following Constitutional Amendment Acts introduced the 10th schedule to the Indian Constitution? Already we discussed it is the 52nd Constitutional Amendment Act which introduced the 10th schedule to the Indian Constitution. Third question is: who or which of the following decides the question of disqualification on the ground of defection? We know the answer, that presiding officer of the house decides the question of disqualification on the ground of defection. No other can interrupt. The fourth question is: disqualification of a member of parliament on the ground of defection will not apply. Options are: if a nominated member joins any political party after 6 months, as already we get no in provisions. So option A is wrong, because if any nominated member joins any political party after 6 months, he is liable to disqualifications. Then option B: if he goes out of his party as a result of merger of party with another party. As we know that 91st Constitutional Amendment Act introduced a new provision which says that two-thirds of the majority merge with another party, which is not liable to disqualification. Means for the given question, the right answer is if he goes out of his party as a result of merger of party with another party, not liable to disqualification. So option B is right answer. Let us see two more options. Option C: if he voluntarily given up his membership of the political party, yes, he is disqualified. Option D: if he abstained from voting in the house contrary to the direction of the political party, yes, of course, it also liable to disqualification. The question asked which one of the following not applicable for the defection. So right answer is B. Let us discuss the final question, which is asked in UPSC Civil Service Preliminary Examination 2022. The question is, with reference to anti-defection law in India, consider the following statements. Two statements are given. First statement is, the law specifies that a nominated legislator cannot join any political party within 6 months of being appointed to the House. This statement is absolutely wrong because the law specifies that a nominated legislator can join any political party within 6 months of being appointed to the House. First statement is wrong. Let us see the second statement. The law does not provide any time frame within which the presiding officer has to decide a defection case. This statement is absolutely true because law nowhere specifies that presiding officer has to decide within a time limit. The correct option for the given question is option B, 2 only. If you are new to this channel, please do subscribe, and if you like the video, click the like button. Thank you for watching.